Let's go to this now. In November last year, 6 Western states filed a joint application before the International Court of Justice arguing for the expansive understanding of genocide. Now, the intervention, as it is legally termed by, among others, Canada, Denmark, Germany, the Netherlands, among other countries, relates to the genocide case the Gambia filed against Myanmar in 2019. Let's look at the significance of this move and what does it then mean for how the court charts a way forward. We speak to Associate Professor of International Law at Roskilde University, Kerstin, Carlson, and Associate Professor of Global Political Sociology at the same university, Gissel. Sorry, pardon me. Thank you so much to you both for your time. I'm going to start with you, Kerstin, because when one sees this intervention and looks at what has been said and what the countries have to say, I wonder then, when we start with how significant this intervention is, what would be your response?
I guess I have sort of a twofold response. One, it's significant in and of itself because it wants to expand, as we wrote, how we understand genocide. So how genocide can be legally applied. So far, there have been very few genocide cases. Recently, of course, South Africa filed a genocide case against Israel. But before that, the case that the Gambia brought against Myanmar was the first time that another state had brought this erga omnes, we call it, this universal jurisdiction. A jurisdiction expands beyond a case against a state with whom it was not at war. So states that were unrelated bringing a case. But even though we've had this kind of upsurge in cases that have come from these two African actors, we still have a very sparse jurisprudence that's come out of the International Court of Justice. And so this genocide, the joint intervention, the ways that these 6 countries suggest that genocide should be interpreted and seen, is a widening and a consolidation of previous genocide case law from other courts that could have really big meaning and an important meaning for the International Court of Justice. And that, of course, the second point was that anything that happens in one case automatically will have an import and an impact on other cases.
Lene, then, one viewer would ask that if you do then, and you make this consolidation and you look at other cases as well, how then does it begin to change the way the court operates, particularly when you look at that genocide convention?
Yes, thank you. Well, we don't know yet how the judges of the International Court of Justice will consider this intervention. So we found it interesting because it also suggests that these 6 Western states actually think about genocide in a more creative way by drawing on another area of international law, that is international criminal law. And it's also the same 6 states which, of course, have been very supportive of Israel in the current conflict in Gaza, which we just saw some footage from. So we think it's legally interesting because of what Kerstin just explained, but also politically interesting in case that this new interpretation is taken up by the judges of the International Court of Justice as well.
And Lena, let me say with you, because, Kerstin mentioned this in her opening remarks. Some see the work of the ICJ, for example, as important, but the fact that, it has heard just 2 genocide cases to date, and the enforcement becomes an issue. For some, they look at this as a possible failure, but I wonder where does it put then that view of those who are watching from the outside in, who say that really this is just, window dressing.
Yes. Well, there's always the critique, and I think it's also valid that international law can only do so much. But at the same time, even though we don't have a world police that can arrest states if they violate international law, at the same time, it doesn't mean that international law is completely meaningless. So we are somewhere between politically significant and legally significant. And also because affairs accumulate. So we might have one judgment which in the moment doesn't seem to have a lot of traction, but then over time that becomes more significant and becomes a source of political pressure, or what maybe we could call social pressure in the international community.
Kerstin, Lena talks about something very interesting, politically significant and legally significant, and also looking at what has been happening in some of the international criminal courts, for example, with some of the cases that we've seen. Are we likely then to see others go the route, more of them, the international criminal courts route, or could this change just how things are being done? Of course, we know they haven't ruled just as yet.
Sorry, that's a great question, and I do not know. So I think one of the things that's interesting about this is, as Lena mentioned, it opens up, you see this opening in the venue of international law for a place that's politically closed. So these 6 states that have made the intervention in the Gambia case are 6 states that have either been silent or, in fact, have said that they are not supporting South Africa's case. But their interpretations of genocide, their applications, their use of the consolidation of previously existing international criminal law cases to broaden what kind of circumstantial evidence can be constitutive of genocide and how genocidal acts can be interpreted, how we can find intent in what happens on the ground. All of those arguments they've made, those legal arguments they've made, are now open. They're available for anyone to take hold of and to use again.
Kerstin, does it then give us an insight into their positions also regarding this issue? Because in some instances, we haven't really heard much, particularly their positions on South Africa's case.
Again, such a great question, and I don't know. I think states are complex. They're made of a number of different institutions, and so there's always a chance that you can have one track moving one way and another moving another. Yeah. And I think as a person who's interested in international law, I always find it quite optimistic making, even though, as you mentioned, there's a lot to be pessimistic about in terms of what we imagined as the promise of the Genocide Convention and what we've actually seen in practice. But to the degree that international law creates a space for debate, for reasoned debate, for pushing principles and ideas forward, I think that's very powerful. And you can see the ways in which, in this joint intervention, states who are politically foreclosed, who've been silent in certain ways, push forward the application, a progressive and demanding application of how it is that violence should be construed as genocidal.
Lene, and I'd like to latch on to that point by Kerstin, because it translates from the policies, it translates from the decisions that are made in the courts right to the ground, to where the people are, where the people are hoping to see some kind of action. Does it then give it a much more kind of like a bit of a hopeful view from some on the ground who are saying that if international law is starting to talk about these, uncomfortable issues, starting to look at some of these broader definitions, we may see some changes in some of the areas where we've seen some really, really violent scenes unfold?
Yes, I think certainly if the court finds that these acts are genocidal, it'll definitely legitimize all those who feel suffering. And it'll also, I'm sure, bring shame on the government of Israel, if that will be the case. But I think there's also a significance that actually goes beyond Gaza here. And I think that's a sort of very interesting significance. And that's because right now, at the moment, Israel is feeling that that everyone who criticizes it are posing an existential threat to the state of Israel. So Israel feels that whenever the world community is criticizing the violence, they actually sort of implicitly saying, let's not have the state of Israel anymore. So it feels very existential for Israel. But what I think is so beautiful about the South African referral to the International Court of Justice is actually that South Africa shows or has shown the world that you can actually reform as a state without ceasing to exist. So in that sense, I think the South African government has stepped onto the world stage in a different way, where it actually shows the world community that you can have a terrible past and you can start hard work of reforming yourself away from a path of the structural, systemic and racial violence, and still come out of it on the other side, albeit, of course, in sort of imperfect ways, which all states are. So in that sense, I think one of the symbolic things that are going on at the moment is to basically show Israel that you don't have to not exist if even if you dismantle what some consider apartheid.
And Kerstin, we're almost out of time, but let me just ask you this very briefly. When it comes to South Africa's case, there was, of course, a lot, when you look at the Genocide Convention, a lot of focus on intent, and South Africa, of course, painting its case there. How would you say it fared?
It fared. So, yeah, there's been a lot of back and forth, but I would encourage anyone who's interested in international law to take a look at the joint intervention. You can find it on the internet. It's 22 pages long, and it's pretty clearly written. I mean, law is often dense. One of the things that a lot of sort of international law specialists were talking about was the problem of what kind of atrocity crimes can be considered. The Genocide Convention only allows the International Court of Justice to look at genocide. So war crimes or crimes against humanity, which of course are very serious crimes, and they have terrible implications and terrible suffering for the people who are living them. But those crimes actually are not crimes that the International Court of Justice can look at. Those are not crimes that are included in the Genocide Convention. But one of the things that's interesting, and again, the joint intervention in a different case, but one of the things that's interesting about the ways in which the joint intervention states encourage the International Court of Justice to think about the crime of genocide is the ways in which they suggest that when certain victims, when certain populations are targeted, so children or sexual and gender-based crimes, that those crimes in themselves, because they have no military significance, they cannot be defended as casualties that can occur in war. It's not something that the laws of war permit. Therefore, we can actually look at those kind of victims and we can draw inferences about what that might mean for genocidal intent. And again, in terms of genocide, intent is the thing that is the hardest to demonstrate. Legally, intent is always hard to demonstrate. How do you connect an act to what a person meant to do? So that's always a hard question. But this joint intervention gives a series of suggestions about how we can read crimes on the ground and connect them to intent, the necessary intent for genocide.
Let me thank you both for your time, and really ending off with Lena's statement there. It's a politically significant and legally significant moment, and it's going to be interesting to see how the way forward is being charted here. But thank you so much for your time and this riveting conversation to both of you. Associate Professor of International Law at Roskilde University, Kerstin Carlson, and Associate Professor of Global Political Sociology at the same university, Lena Gissel.